because everybody's perspective is important.
If they're willing to share it, yes.
And as a matter of fact, you've gathered, as I understand it from today, I want to say around 300 terabytes of video information from the scene. Is that right?
I believe there's in the region of 248 terabytes of data from Utah Valley University alone.
And the adult child of Mr. Grunander is in the exact same position as everybody else who's given evidence in this case, isn't she?
In terms of being an attendee at the event?
Right?
Yes, she was an attendee at
And
the
having
event.
video
Yes.
and having witnessed things herself?
You would have to refer to her testimony as to what she witnessed.
Okay. And you mentioned, I know I have 2 minutes, I'm going to talk very fast. I know she's about to kill me. You mentioned the DNA evidence. You're certainly not a DNA expert, is that correct?
I'm not, no.
And are you aware that the DNA evidence that was seized from the scene consisted of a mixture of at least 5 different individuals?
I'm not a DNA expert, so
So you know enough to say what helps him, but you're not going to answer whether or not there were 5 individuals mixed into that DNA?
I'm not aware of that, no.
Okay. And you're certainly not qualified to interpret complex DNA mixtures, are you?
No, I'm not.
Okay. Court's indulgence for just one moment, Your Honor. Six minutes.
Ms. Nestor, is there, I know I gave you that 6 minutes. Is there any other questions that you feel you need to ask?
Thank you for asking, but I think I'm done. Thank you.
Thank you. All right, that concludes the taking of evidence, this portion of the hearing. We'll turn to closing arguments or arguments by the parties as it relates to this. May this witness step down.
Yes.
As much as he'd like to sit there indefinitely. We'll go ahead and excuse him. All right, counsel, we have, just before we begin, I note that we have a hearing set on the break for February 24th at 10:30 on WebEx. Does that comport with the agreement of the parties?
On what day, Your Honor? I'm sorry.
February 24th at 10:30 in the morning on WebEx?
Thank you, Your Honor.
All right, and so it's the intent that the court will issue an oral ruling and a written ruling on that same day. And at that time, depending on how the court rules, will determine what we address next in regards to the motion regarding media in the courtroom. And so we'll take to that point. I do wish to state that this court's mind is not made up, and that I would ask all parties to continue in their roles because the court has not issued a decision in regards to the disqualification of the Utah County Attorney's Office. So I would ask that all parties continue to move forward diligently as they have, and have made a note of that. All right, so it's 4:37. My lawyer math, let's see. It looks like you would get 10 minutes each for your arguments, and we will end at 5. And if you want to reserve time, you certainly can do so, but take that into account when you're making your argument. Mr. Novak.
Thank you, Your Honor. Your Honor, there are legal issues and there are factual issues that we think that the court needs to look at very closely. I would ask the court, because I only have 10 minutes, to look at both the briefing in the original motion, and I will point out some specific cases that we think the court should pay attention to, as well as the briefing in the, what I'm going to call the renewed request. And they're both informative. The briefing in the renewed request doesn't just go to the question of should this court encourage, that's the language that the statute hints at, the state attorney, the county attorney to refer this to the attorney general, but it also refers to when a trial court does or does not abuse its discretion with respect to recusal. The last witness, and I'm gonna just go with the principle of recency here, the last witness's primary purpose was to focus on this question of whether the adult child student at UVU is what the state has referred to as a material witness or a critical witness. And that is actually either intentionally or unintentionally a distraction from the real question here. This is not a question of whether, in order to prove its case, the state needs to call as a witness a family member of the prosecution, okay? That could, in another situation, be a source of a conflict. But the issue here is that the most experienced and most senior prosecutor in the office, other than the elected county attorney, Mr. Gray, should have been walled off from this prosecution until this court had an opportunity to consider whether disqualification is necessary. And it is important to note a couple things that Mr. Garnander said. One of them was that he'd never seen, in his experience, a decision to seek the death penalty made without regard to information about the accused. And there's a hint there that there was an emotional response to Mr. Kirk's death, which there's a strong implication creates an appearance of impropriety. And so this court doesn't have to make a finding that there's a conflict of interest, an actual conflict of interest. What the standard says, and that's the standard that Mr. Gray read into the record from the organization of Utah prosecutors that he's the president-elect of, which refers to the public perception of the integrity of the prosecutor's office and the public confidence in the handling of the case, okay? So that was standard 1.3-3C. The failure of Mr. Gray to, at least temporarily, wall off Mr. Grenander, to seek guidance from any other prosecutor, ethics expert, the court, the state bar, people who are leaders or members of SWAP, the Attorney General's office, demonstrates both a very an inappropriately casual approach to this issue, and it also demonstrates that what Mr. Gray did is he put his need for Mr. Grenander to lead this case ahead of the ethical consideration of whether that might create an appearance of impropriety. Not an appearance in Mr. Gray's opinion, not an appearance in Mr. Grenander's opinion, but an appearance in the public eye. And that's actually your Honor's project, if I may, is to determine what a reasonable member of the public would think of this scenario. The other thing that is important here is that we are dealing with a proceeding where the Eighth Amendment to the United States Constitution and the parallel constitutional right in Utah require, and this court has heard it already, and the court's going to hear it over and over again, a heightened standard of reliability. This is not just a court proceeding, and it's not just a criminal proceeding. This is a capital proceeding, which is, at this point in time, sort of almost the only proceeding where the Eighth Amendment comes into play. And so this court needs to view the appearance of impropriety under this heightened standard of reliability. A couple Utah cases that I think that this court, we would ask this court to look at very closely. State v. McClellan, Utah Supreme Court, 2009, Utah 50. State v. Cater, C-A-T-E-R, 2014, I'm sorry, yeah, that's a Court of Appeal decision, 2014, Utah Appeals 207. Mr. Gray should have implemented a firewall, and he didn't. And that has created this problem. And then what we see is isolating Mr. Gronander's daughter from the investigation, isolating her in some way so that she hasn't provided a statement, she hasn't provided videos until we bring this issue to the court's attention. The decision as to what charges to file, the decision as to whether or not to seek the death penalty should never, ever have been made in consultation with Mr. Gronander, even if he's the most experienced homicide prosecutor in the office, even if he has one of the longest tenures, and even if it's Mr. Gray's ultimate decision. Because now we don't really know, and the court doesn't know, and the court just can't defer to the prosecution. That's the whole point of the court having the supervisory power over this issue. What influenced Mr. Gray? I would also point out that Mr. Gray did not disclose until asked, while under oath, that two members of his faith community were also present there. That was not disclosed to us when he found out about it, and that he has a relationship with the family of some young person who was also negatively impacted. This line of sight analysis, this PIE that has been diagrammed is not the question. That is not the question. The question is whether Mr. Gray should have isolated the prosecutor whose child was there, and I say this with all due concern and respect, could have been injured in any number of ways. People could have been hurt leaving the scene. And I'm not saying that in any way to minimize the effect that that experience had on Mr. Gronander and his family. I think, as I said in court last time, I've been through this, where I learned that my child is somewhere where there was a shooting. And until I knew my child was safe, that was, an overwhelming emotional experience. So the problem is that Mr. Gray approached this in an incredibly casual way. There isn't a single memorandum, he testified to this, documenting the process of whether there's an actual conflict or an appearance of conflict. The mere disclosure of it to us and us bringing it to the court does not wash this clean. That is our concern. I also want to cite the court, because I'm running out of time, to a decision that is not a Utah decision, but it's cited on page 12 of our motion, which is Tate, 925 Southwest 2nd, 548, a Tennessee decision, where basically the court says where there were no screening procedures and the prosecutor, as to whom there was an appearance of impropriety, maintained the role of a supervisor, and there was open discussion of the case with him, there should have been a disqualification, and what the court did there is it disqualified the entire office. So this problem could have been avoided if Mr. Gronander had been screened off, if Mr. Gray had sought this court's guidance early. The state, they were in court on September 16th. This could have been brought to the court's attention in September. Counsel were appointed shortly thereafter. We could have addressed this a long time ago. and now frankly, it's too late. So we understand that there is pressure on the judicial system to move this case expeditiously. There is also a countervailing, and we believe, stronger need to make sure that there's a heightened standard of reliability, that there is no conflict, and that there is no appearance of conflict. And if that takes a little bit of time for another prosecution office to get up to speed, the investigation's gonna continue, the discovery production's gonna continue, the lab work's gonna continue, none of that is gonna change. So we would ask the court, I'm not reserving any time in rebuttal, I'm gonna ask the court to grant the motion, both parts of it, which is to make a finding that Mr. Grunander should have been walled off and that Mr. Gray's failure to do so, and sort of the casual way that Mr. Gray approached this whole thing requires, unfortunately, the disqualification of his office and the appointment of a new group of prosecutors to be responsible for this case. The case will continue. What we are asking the court to do today does not in any way change the fact that Mr. Robinson is charged. He's charged with an aggravated homicide. We all have to deal with that, but we have to deal with it in a way where there is no question that the decisions that have been made or decisions that will be made in the future, which is some questions that were brought up to Mr. Gray by his own counsel, and the public's confidence in the outcome of this case are tainted by what should have happened and did not happen. And I appreciate the court's time.
Thank you, Mr. Novak. To the state, looks like Mr. Novak took 13 minutes.
I'll pay you back later.
Thank you. To the state, I will afford you that same time frame. If you want to take all 13 less, I'll leave it to you.
I know everybody in here is going to blame me if they don't leave at 9, which is 5 o'clock, so. The reality is, Your Honor, the adult child is not a witness here. She didn't see Charlie Kirk get shot. She didn't record him get shot. She didn't see his wound. She didn't see him get carried off. She's just not a witness. And as a result, there's really no conflict here. Now, I understand that conflicts go beyond just that, but most of the cases that we look at where there's some kind of conflict are where there's confidential knowledge that has been obtained by the prosecutor, right? A defense attorney becomes a prosecutor and now has confidential knowledge about that person, right? That's the typical conflict we see. Has some kind of proprietary or financial interest, right? That's the kind of conflict we usually see. Occasionally there are personal conflicts, but there's a lot of good case law that talks about what kind of conflicts constitute that personal interest. And I think the best case law on this is cited in our opposition to the renewed motion to refer the matter. And in that case, State v. Newman, the court found, this is a Missouri case, the court found no conflict of interest in prosecuting a defendant for murder, even though the prosecutor had done business with the victim, knew him personally, and served as a pallbearer at the victim's funeral. In the Gwinnett County District Attorney, nor his Georgia office had a conflict of interest, even though his chief investigator dated and later married the victim in a case that the office was prosecuting. In Kansas, prosecutor's office did not have a conflict, even though the defendant threatened to blow up the very courthouse and also housed the district attorney's office. I mean, these are cases where the prosecutor has a close relationship with the actual victim of the crime. Look, if Mr. Grunander were related to Charlie Kirk, we would acknowledge there's a conflict here, right? But we're not even close to that. The adult child is not even a witness in this case, is not a witness to the murder. Is the child a witness to the circumstances? Sure, but so are 3,000 others, as well as dozens of video recordings. She's not a witness, she's not necessary in this case, and And as a result, there's no conflict here. Now, is he going to be motivated because she was present? Is he somehow going to be motivated to do something he otherwise would not? Well, again, maybe if she were injured, maybe so. Maybe there would be a good argument there, maybe. It still doesn't rise to the level of these cases that I've talked about. But that's just not the fact. She has not been traumatized. She has not had to seek therapy. She has not had to miss class. It's not affected her friendships. As a result, the idea that Mr. Grunander is going to be motivated by some kind of retribution for what happened to her is just flatly false. The idea that the defendant was charged for killing someone because a prosecutor's child was present when it happened is just, it's almost laughable. He's being prosecuted for killing someone because he killed someone. At least that's what the evidence will show, we believe. The idea that he has been, that the death penalty has been elected because a relation of a prosecutor was there is just laughable. It's because someone was shot and killed. That's why the charges were brought. I just don't think that proposition is palatable at all. The evidence is what this case was charged on, both at the charging level and at the death penalty level. None of this was motivated because of some relationship, and I think that anybody who looked at this would agree that you don't charge someone with murder because a witness was affected by it. You charge someone with murder because someone was killed, right? The standard. The defense has tried to elevate the standard here by looking at best practices, the SWAP's Statewide Association of Prosecutors best practice. Even so, I think it's been misstated. The standard says that when there's an appearance of conflict, the prosecutor should, I quote, consider recusal. Well, that's the question. They should consider it, right? It doesn't say it mandates recusal or disqualification. And that's not even the ethical standard that this court goes by. That's the best practice. And the best practice was followed in this case because once that fact was known, there was a discussion. Of course, it was disclosed immediately. It was disclosed 5 days after defense counsel was appointed. The idea that the child was isolated is just flatly false. She just was not a witness. And the follow-up with her showed as much. The standard is there a significant risk that representation of the state will be materially limited by a personal interest of the lawyer? In this case, the decision to prosecute and the prosecution of this case will not be limited in any way. Moreover, if anything, the interests would align. Regardless, the motivation here is clearly not because of the presence of this child, it's because Charlie Kirk was murdered in front of everybody. She's not a material witness. Everybody knows Charlie Kirk was shot and killed and murdered brutally. Everybody knows that. I don't think that's going to be what this case is about. It's going to be about identity. And neither the child nor any of the other 3,000 witnesses present really have a whole lot to say about who this was that did the shooting. And that's what this case hinges on. There's been no evidence that Prosecutor A's child had any effect on the prosecution of this case to date. And there's no reason to believe it will have any effect in the future. The testimony was clear that no one anticipated that based on her lack of value as a witness and the lack of trauma or injury to her. There really shouldn't be any question about that for this court, for the public, or anyone else. Thank you.
Thank you. Thank you to all parties. I acknowledge the hard work and effort that went into today, and this court appreciates that. We will reconvene on February 24th at 10:30 in the morning via WebEx. And just for clarification, to defense, in regards to Mr. Robinson how would you like Mr. Robinson to be present at that hearing?
Your Honor, Mr. Robinson, I believe it's WebEx for everyone, right?
It is.
He can also be on WebEx, Your Honor. We would waive personal appearance for that.
All right, thank you. All right, with the new date set,
Wait, I'm sorry, just a minute. Oh, sorry, audio only. Thank you for my co-counsel. Audio only, no screen.
all right, I appreciate that clarification.
Thank you, Your Honor.
And with that, court is in recess.
I kind of thought it did, but there was enough confusion for me that I wanted to renew the motion, to make sure that was clear, given the proffer of facts, given the last name of Prosecutor A. It would be easy for an evil wisher, such as the person identified in the proffer of facts, to identify his child and target his child. For that reason, I would ask to oppose the testimony of Prosecutor A.
Defense.
We join in that motion.
And is the media wishing to weigh in on this portion?
Again, the media does not object to the closure of this portion.
All right, thank you. Let me address this issue. And a lot of this is repetitive, but being that this is the motion being made, I will put on the record the preamble to my ruling. The court has reviewed the parties' prior arguments and the materials submitted in advance of today's hearing, including entitled Proffer of Facts Regarding Closure of Portions of Evidentiary Hearing on Motion to Disqualify Utah County Attorney's Office. Defense has requested the testimony of certain witnesses, specifically Prosecutor A, adult child witness, be received in closed session pursuant to Utah Rule of Judicial Administration 4-202, citing concerns related to personal privacy and safety. The court acknowledges that Rule 4-202 permits limited closure of court proceedings in appropriate circumstances. At the same time, the court is required to consider the countervailing interests identified in Rule 4-202, including the public's right to observe the conduct of public business, to understand the operation of government, and to maintain confidence in the judicial process. The court must also remain mindful of the constitutional rights of Mr. Robinson, as well as the statutory rights of Ms. Erika Kirk in her role as victim representative. And I also note that she filed today notice in regards to open and transparent courts. So I just want to touch on that. I acknowledge that filing as a victim representative. The purpose of today's evidentiary hearing is limited and specific. The court is asked to consider the defendant's claim that a member of the prosecution team, which was previously referred to as deputy county attorney in the motions, has a personal conflict of interest, that any such conflict extends to the Utah County Attorney's Office, that disqualification is therefore required. The court's role at this stage is to receive relevant evidence and to rule based on the record and applicable law without reaching the merits of those claims in advance. The parties have filed public motions outlining the anticipated evidence and testimony related to the motion to disqualify, including the state's opposition, the defense reply and request to take evidence, and the defense original motion. Those filings describe the general subject matter expected to be addressed at this hearing. The defense asserts that the prosecutor's familial relationship with a witness creates a concurrent conflict of interest implicating Mr. Robinson's due process rights. The prosecutor's role, duties, and actions in this matter are therefore relevant to the issues before the court. If the prosecutor is called to testify, as it seems they will be, the court will consider the testimony as part of the evidentiary record. After careful consideration of the record, the arguments of counsel, and in the interests identified in Utah Rule of Judicial Administration 4-202, the court finds that closure of the prosecutor's testimony is not necessary and would not be narrowly tailored on the circumstances presented. The court further finds that the interests of openness and transparency outweigh the asserted grounds for closure as to that testimony, and the rights of the parties and witnesses can be adequately protected through least restrictive means available to the court. For those reasons, the request of both the state and the defense to conduct the prosecutor's testimony in a closed session is respectfully denied. You may call your next witness, Mr. Burt.
Your Honor, I call Prosecutor A.
All right.
And I assume from the court's ruling, we do not need to do a closed session as to his identity?
We will not be doing a closed session as to his identity.
Thank you.